Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I'm Mary, and I'm here with my co-host, Aaron. Today we're examining the 3 traditional elements required to obtain a writ of mandamus in federal court.
This episode gets into the legal doctrine behind mandamus. If you're considering a lawsuit to compel USCIS or another agency to act on your delayed application, understanding these 3 elements will help you evaluate the strength of your case.
So what are the 3 elements?
To obtain a writ of mandasum, a plaintiff must establish 3 things. First, a clear right to the relief sought. Second, a clear duty on the part of the defendant to perform the act in question. And third, the absence of any other adequate remedy. Courts sometimes phrase these slightly differently, but these are the core requirements.
Let's take them one at a time. What does it mean to have a clear right to relief?
The plaintiff must demonstrate that they have a legal entitlement to the action they're seeking. In the immigration context, this typically means showing that you filed a valid application, that you're entitled to have that application adjudicated, and that the agency has failed to act.
How does an immigration applicant establish this?
By documenting their application. You show that you filed a complete application with USCIS or another agency, that you paid the required fees, that you submitted the necessary supporting documents, and that the application remains pending without a decision.
Is it enough to just want a decision?
No. The right must be grounded in law. Congress has established various immigration benefits: green cards, citizenship, work authorization, asylum, and has created application processes for each. When someone files an application under these statutes, they acquire a legal right to have that application reviewed and decided. That's the clear right.
What if the application has deficiencies?
If the application was accepted by the agency and a receipt notice was issued, the applicant generally has a clear right to a decision, even if that decision might ultimately be a denial or a request for additional evidence. The right is to an adjudication, not to a particular outcome.
Can you give some practical examples?
Sure. An applicant who filed Form I-485 for adjustment of status 3 years ago has a clear right to have that application decided. An applicant who filed Form N-400 for naturalization and completed their interview 18 months ago has a clear right to a decision on their citizenship. An investor who filed Form I-526 for an EB-5 visa has a clear right to have that petition adjudicated.
What about someone who hasn't filed anything yet?
They would not have a clear right to mandamus relief because there's no pending application. The right arises from having an application before the agency that the agency has failed to act upon. Without a pending application, there's nothing to compel.
Are there situations where the right might not be clear?
Potentially. If there's a genuine question about whether the application was properly filed, whether the applicant is in a category eligible for the benefit, or whether some legal bar applies, the government might argue that the right is not clear. But in most straightforward delay cases, where a valid application has simply been sitting without action, the clear right element is satisfied.
Let's move to the second element. What is a clear duty?
The second element requires the plaintiff to show that the government defendant has a clear, non-discretionary duty to perform the requested act. In immigration mandamus cases, this means showing that the agency has a legal obligation to adjudicate the pending application.
Where does that duty come from?
Multiple sources. The Immigration and Nationality Act establishes various benefits and implicitly requires USCIS to process applications for those benefits. The Administrative Procedure Act explicitly requires agencies to conclude matters presented to them within a reasonable time. Together, these statutes create a duty to adjudicate.
What does nondiscretionary mean in this context?
It means the agency doesn't have a choice about whether to perform the duty. The agency has discretion over how to decide the application, approve or deny, but it does not have discretion to simply ignore the application indefinitely. The duty to make a decision is mandatory, not optional.
Is the duty to adjudicate well established in immigration law?
Yes. Courts have consistently recognized that USCIS and other immigration agencies have a non-discretionary duty to process applications. The agency must review the application, evaluate the evidence, and issue a decision. What the agency cannot do is leave applications in limbo forever.
How do courts analyze this?
Courts look at the statutory and regulatory framework. For naturalization, for example, Section 336 of the Immigration and Nationality Act specifically addresses examination procedures and timelines. For adjustment of status, the statute provides that USCIS may approve applications that meet the requirements, but implicit in that authority is the duty to actually review and decide.
Are there any limits on this duty?
The duty is to adjudicate, not to adjudicate immediately. The agency can take reasonable time to process applications, conduct background checks, and gather necessary information. The mandamus question arises when that time becomes unreasonable. But the underlying duty to eventually decide exists from the moment a complete application is filed.
Does the government ever argue there's no duty to act?
Rarely in straightforward delay cases. The government typically doesn't dispute that it has a duty to adjudicate. Instead, it argues that it's fulfilling that duty at a reasonable pace, or that the delay is justified by legitimate factors like background checks or resource constraints.
So the duty element is usually not the battleground.
Correct. In most immigration mandamus cases, the dispute centers on whether the delay is unreasonable under the track factors, not on whether the agency has a duty to act. The duty to adjudicate is well established. The question is timing.
Are there cases where the duty is genuinely unclear?
There can be. For example, in cases involving consular processing, the doctrine of consular non-reviewability complicates the analysis. Consular officers have significant discretion in visa adjudications, and courts have struggled with whether there's a judicially enforceable duty to act in those contexts. We'll cover consular processing in a later episode.
That brings us to the third element. What does it mean that there must be no other adequate remedy?
Mandamus is considered an extraordinary remedy. Courts will only grant it when the plaintiff has no other adequate means of obtaining the relief they seek. If there's another legal avenue that would provide the same result, the plaintiff is expected to use that avenue instead.
What would count as another adequate remedy?
An administrative appeal process, for example. If the agency denied your application and there's a procedure to appeal that denial within the agency, you would typically need to exhaust that process before seeking mandamus. Or if there's a specific statutory remedy that addresses your situation, that might be considered adequate.
How does this apply to delay cases?
This is where immigration delay cases are often strong. When the problem is agency inaction, no decision at all, there's usually no adequate alternative remedy. You can't appeal a decision that was never made. You can't seek administrative review of silence. The only way to compel the agency to act is through judicial intervention.
Does the applicant need to exhaust administrative remedies before filing a mandamus case?
Generally, no, at least not in the traditional sense. Courts have recognized that exhaustion requirements don't apply in the same way when the complaint is about agency inaction. There's nothing to exhaust when the agency hasn't acted.
But are there things like case inquiries and ombudsman requests?
Those exist, and as we discussed in earlier episodes, it's often advisable to make some effort to resolve the delay through those channels before filing suit. But they're not formal prerequisites to mandamus jurisdiction. A court won't dismiss your case solely because you didn't file an ombudsman request first.
So the no other remedy element is usually satisfied in delay cases.
Yes, when an application has been pending for an extended period with no decision, there's typically no administrative remedy that will compel action. That's precisely why mandamus exists, to fill the gap when an agency's inaction leaves the applicant without recourse.
How do these three elements work together?
They function as a checklist that courts use to determine whether mandamus relief is appropriate. The plaintiff must satisfy all three. Having a clear right isn't enough if there's no clear duty. Having both a clear right and a clear duty isn't enough if there's an adequate alternative remedy.
In a typical immigration delay case, how does the analysis go?
The plaintiff shows, I filed a valid immigration application, establishing my clear right to have it decided. The agency has a statutory and regulatory duty to adjudicate that application, establishing the clear duty. And because the agency has simply not acted, there's no decision to appeal and no administrative process that will compel action, establishing that there's no other adequate remedy.
And if all three are met?
Then, the court has the authority to issue a writ of mandamus, compelling the agency to act. Whether the court will actually do so depends on the track factors analysis, whether the delay is unreasonable under the circumstances. But satisfying the three elements gets you in the door.
How does the government typically respond to these elements?
The government rarely disputes the first two elements directly in routine delay cases. Instead, the government usually argues that even if the elements are met, the delay is reasonable, and the court should exercise its discretion not to grant relief.
What about the third element?
Occasionally, the government argues that the plaintiff hasn't adequately pursued administrative remedies, or that some other process is available. But these arguments are often weak in delay cases because, again, there's no meaningful administrative remedy for inaction.
So the real fight is usually over reasonableness.
Exactly. The three elements establish the court's authority to act. The track factors determine whether the court should act. Most mandamus litigation focuses on the track analysis rather than the threshold elements.
Why is it important for applicants to understand these three elements?
Because it helps you evaluate your own case. Before filing a lawsuit, you should be able to articulate, what is my clear right? What is the agency's clear duty? Why is there no other adequate remedy? If you can answer those questions clearly, you have the foundation for a mandamus case.
What if one element seems weak?
Then you need to think carefully about whether mandamus is the right approach or whether there are steps you can take to strengthen that element. For example, if your application might have been incomplete, you might want to confirm its status with the agency before filing suit.
So this framework helps with case evaluation.
It does, and it helps you understand what your attorney is doing when they draft the complaint. Every mandamus complaint addresses these three elements, explaining why each is satisfied. Understanding the framework helps you be an informed participant in your own case.
Let's summarize the key points from this episode.
First, to obtain a writ of mandamus, a plaintiff must establish a clear right to the relief sought. In immigration cases, this means demonstrating that you filed a valid application that remains pending and that you're entitled to have it adjudicated.
Second, the plaintiff must show that the government has a clear, non-discretionary duty to perform the requested act. Immigration agencies have a well-established duty to adjudicate applications within a reasonable time. The duty to decide is mandatory. The agency has discretion over the outcome, but not over whether to act at all.
Third, the plaintiff must demonstrate that there is no other adequate remedy available. In delay cases, this element is typically satisfied because there's no administrative appeal or alternative process that can compel an agency to act on an application it has been ignoring. Together, these three elements establish the court's authority to issue mandamus relief.
Thank you for listening to the Mandamus Lawyers podcast. Mandamus Lawyers is a law firm focused exclusively on federal court litigation for immigration delays. Visit mandamuslawyers.com.